Good afternoon.
Afternoon.
So welcome everybody to June's edition of Medicaid Monday. As you can tell, I'm not joined by Lou or Aaron. They're usually the co-hosts with me. They are off doing some of the things today. So thankfully for all of you, I'm not by myself because I think you would get tired of me talking at you with no one else to ping ideas off of. So we're very fortunate, very grateful to have Mr. Tommy Marasco on. He's one of our associates from our New York City office. So the rest of the firm is now on the slide in front of you. So again, we are Pierre O'Connor and Strauss. We are a full service elder law firm. Our main office is located in Latham, right in the Capital District area, but we do have a full-time office in New York City, which is where Tommy is located. So if you want to come to Albany, you can see me. If you go to City, you have to see Tommy or some of the other staff that we have there. So today, just to have an agenda, we're going to talk about our Medicaid Asset Protection Trust more than anything. And it's a frequent topic that we discuss here. I think we do a program on it every year for Medicaid Monday. We thought this might be a good time to kind of refresh everyone's understanding of it. We wanted to revamp our example with it because we do have new numbers, which obviously we will go through. And then we're going to talk about some other things. So we're going to talk about some exempt assets where you don't even need to use a trust. We're going to talk about the trust itself. We're going to talk about using an example of someone who needs home care, Medicaid community benefits now and how a trust kind of fits into that equation. And we're going to talk a little bit about Medicaid applications. So we're planning on kind of speaking about the topic for around a half hour, and then right around 12:30, we'll try to wrap up this portion of the program, and then we'll take some Q&A and we'll kind of see where the rest of the afternoon takes us. But again, thank you for being with us here on this lovely Monday. It's only downpouring outside, so thank you for doing that. So we do this every time we do Medicaid Monday, whether it's kind of directly related to the topic or not, because ultimately all the topics we do are tied to Medicaid to some degree. So whether this is the first time you're joining us or whether this is the sixth time you're joining us just for this year, there were some adjustments for Medicaid for eligibility purposes. So again, we have mostly good news where we did see increases. The bad news is they were relatively slight. So if you're a single person at home, you have an income allowance now of $1,820 per month, which is up $68 from last year. If you're a couple where both spouses are applying, your now combined income limit for the household is up to $2,453. If you have a spouse receiving Medicaid, but you are well, your community spouse or income allowance, that minimum monthly maintenance needs number is now up to $3,948. And then the last number is the most depressing, and it is the most smallest number on the slide. And that's unfortunate. If you're in a nursing home needing Medicaid, you get to keep $50 of your income. Been that way since 1965. They have not changed that number. Whether they ever will or not, I don't think it's likely at this point. They've only had since 1965 to change it, but I guess who knows? Anything technically is possible. And then with resources or assets, because those terms are used interchangeably, again, slight increases for this year. So again, mostly good news. So if you're a single person needing to get on Medicaid, you now can have $32,396 or less of assets. If you're a couple, again, it's up to $43,781. And if you're that community spouse where your spouse is on Medicaid, you are not, the minimum amount you're allowed to keep is $74,820. And it's been that number for quite some time. The upper tail has now gone up to $157,920. So again, slight increase, not huge, but again, more money, even if it's slight, is typically always good. So let's talk about exemptions. So, because I think one of the things, Tommy, that we see a lot of when we counsel people on this is people come in, and I think a lot of times people have heard of Medicaid. A lot of people then presume that they will never qualify for it. And I think one of the nice things that we get to do as the attorneys involved with this process is we get to counsel people that maybe things that they already have might not even count towards this equation. So I know the first one that obviously we can knock right off the top is that $32,396. That's your allowance, right? You are allowed to have up to that amount of money or assets reaching that value without any questions asked. Second one that again, we get to counsel on, which is a little depressing, unfortunately, is that you can prepay your burial and there is no dollar amount for that. Next one is that income reducing property. So is this something that you see a lot in your practice, Tommy? Just for my education here?
Typically, not as much.
Okay. I say that's how I feel about it as well.
Yeah.
Usually we use this exemption if we have somebody who's applying for Medicaid and they have an active business, like where
Yeah.
the business is still running. They might have some physical ailments that are leading to their need for, obviously for services, but they're still able to run a business like
Sure.
from home or from whatever setting they're in. So and I would say on the few times where we're presented with that example, the business itself, as long as it is an active business
Right.
producing income, it's exempt. So we don't have to necessarily throw that into the equation.
Right.
Life insurance, this is a huge thing where I feel like, if we wanted this to work a little bit better, we should have the numbers adjusted a little bit. Because again, these numbers have been set since 1965. So you could have a very, 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 very small amount of life insurance, meaning that the face value of the policy or total policies that you have to be less than $1,500. If you have that, then your life insurance does not count. Again, not indexed for inflation. These days, with the cost of burial, funerals, all that stuff, many, many, many people would need a lot more than that to bury themselves. But if you have had a policy for a very long time that's really just very small in value, you certainly can have a very small one and where it's not counted. Big one though is the next bullet, Tommy. So you want to go through that next one with the IRA?
Yeah, this is what I believe is what I encounter most with clients. And it's that your IRAs, provided they are in payout status and they do not have a Roth designation, meaning they are pre-tax dollars, not post-tax dollars, then the principal value of that retirement account is exempt for Medicaid purposes. With the only exception is that the income will be counted towards Medicaid. However, you have to maximize the distribution rather than just taking your required minimum distributions.
Yeah, that's a lot to unpack.
Yeah.
Essentially, the take home point here is if you have an IRA, it is exempt as long as you're typically past 73, where you're required to take distributions.
Right.
Roths, we've been able to exempt by treating them as traditional so far. We don't know whether that will continue to be treated that way because there actually is no law technically on the books for Roths. So we'll have to kind of see how that plays out. And then there is that maximization of income. So unfortunately, the best thing I think that we could say quickly on that, because we could spend a lot of time just talking about that in and of itself, is that is a county specific principle. Some counties require you to take more from your IRA than others, but essentially, as long as you're taking what the county deems to be your required payment from your IRA, then the IRA is not a countable asset. And then last one, Tommy, we're gonna tag team this one a little bit. So we have one car. Do you see a value next to that?
Nope.
Yeah, and that's the point, right? You can have one car regardless of its value. So it could be super nice, it could be not super nice, as long as you only have one. Your car is just about anything else that you can think of when it comes to assets is not exempt, for the most part, not always. So your house, it's almost, it's very often the most valuable asset that clients bring to the table when they talk about Medicaid. Not always, but it's usually a very important asset. So sometimes we don't even need to do anything with the house to have it not count, right? For Medicaid purposes. One is if you, your spouse, or a minor or disabled child live in the house, then your house does not count as an asset. So if it's a home care situation, if you're living in your house, doesn't count. We don't have to do anything with it from a planning perspective to get you qualified. That does not mean we don't want to do other things with it for considerations later. We don't need to do anything with it to get it to get you qualified for Medicaid. There are certain transfer exemptions as well. So we use caretaker child sometimes, like where we've had a child that's taken care of mom and dad, lived with them for at least 2 years prior to an institutionalization, where we can transfer the house free of penalty. Even less so, we sometimes have a sibling with an equity interest as long as they've had it for more than a year. Sometimes we have utilized that. But again, disabled child in the house, always exempt. Spouse in the house, always exempt. And the nice thing is, if you didn't do any planning, even if you wound up in a nursing home, there is something called an intent to return home document that we can use that then would at least exempt your home from Medicaid qualification purposes for a nursing home while we kind of get our ducks in a row and try to figure out the next steps. So we don't usually use intent to return home documents for home care cases. It's much more nursing home, but it is still available and another kind of tool in our toolbox, if you will. Biggest thing though is, and I want to make sure that we're clear, even though we don't need to potentially do anything with your home to not have it count as an asset for qualification purposes, we are always concerned when you own real property about either having a lien placed against it or having an estate recovery situation where the county comes back after it after you pass away. So we typically will try to use a variety of different tools, but here we most likely will recommend either a trust or something with a deed to try to keep the property out of your estate when you pass away. Because when you pass away, if it's not held by a trust or it hasn't been dealt with through certain kinds of deeds, anything that passes through your estate, Medicaid is allowed to recover against. And Tommy, I know that you frequently counsel people on that point.
Absolutely. As you said, this is one of most clients' biggest assets, and obviously the biggest concern.
Yeah. So let's keep moving. So transfers, right? We use trust typically because we want to start getting that ball rolling towards getting through the look back period. So kind of just to make this very simple, there's a 5-year look back for the nursing home. That's been the case for quite some time. No real talk of that changing. And right now, as we sit here doing this webinar right now, there's still no look back for home care. However, there is a 2.5-year look back that is expected at some point. Again, it's been on the books since 2020, still not being enforced. No real talk of it being enforced right now, as far as I know. But again, we have to kind of have that in our back of our mind of that could be coming, and it's been rumored to be coming for a long time. So anytime that you have a look back period, when you transfer things, you might wind up with a penalty of ineligibility. But for now, we're not really worried about that with home care because there's no look back.
Correct.
So in order to protect things against the look back, we use a trust. It's called a Medicaid Asset Protection Trust. There are many types of trusts that we do. This is a type of irrevocable trust, and it can be used for all different types of things. So it can hold different types of assets, such as your house or other real property. It can hold stock. It can hold life insurance, especially if it has a cash value. That's mainly when we'd be concerned with it. It's really anything that would put you over that $32,396 allowance. So if someone comes in, they have lots of assets, they want to qualify for Medicaid in the future, we talk about using this vehicle to start protecting things, getting it off the table, getting it safe from that nursing home or home care if they institute the look back. So Tommy, why don't you walk a little bit through like the mechanics of the trust a little bit?
Yeah, absolutely. So with this specific kind of trust, there are a few distinct features, and one of them being is that we need to create some separation between you and the asset so that for purposes of Medicaid, for eligibility and for future protection, they are looking at it that is not an asset that is available to you that you could use toward your care. So one of the major things is that you cannot be your own trustee. However, a lot of the times people think irrevocable trust, they think that they have a complete relinquishment of control. Is not the case. So you always will have the ability, even in this trust, to dictate who your trustees are and to change them, and also who your beneficiaries are. And we include vehicles in there that also enable you to be able to update those beneficiaries. And one of the biggest other aspects of this trust is that you cannot have direct access to principal. And that is the other biggest keynote takeaway. So one, you cannot be in control of the trust. You are not the trustee, and you cannot be allowed any access to principal.
Perfectly said. Couldn't agree more. So the types of things that would go in here, again, your house, your bank accounts, your stocks, and your bonds, again, not IRA funds, right? This is after tax money, not pre-tax money. If you have non-qualified annuities, life insurance, if you have that business, it's something that certainly can go in here. Other real estate holdings, so it's frequent that people will come in. Sometimes they have like their primary residence. They might have like a camp that they inherited or something like that. All real estate can go in here. Income is typically allowed to go back to the maker of the trust from this type of trust. It's not required. It just is something typically that we build in for flexibility. And as Tommy was saying, principal cannot be given directly back to you if you are the maker of this type of trust. But however, there is what Lou likes to call the backdoor out of the trust. So typically we would allow the children or other beneficiaries to grab principal from the trust, give it to one of the beneficiaries, and then it's their funds to use with as they deem fit. So that could be then turned around and then used for the benefit of the maker of the trust. That typically works quite well as long as you have enough people to kind of throw into all these roles. A lot of times these would be the children, the grandchildren, feeling trustee, beneficiary, all those types of things. If you don't have children or you don't have children that you can trust with these kinds of things, you can rope in just about anybody that you want to these roles. It's just obviously the more distant that they become from a familiar relationship, the more consideration you want to have just to make sure we're picking the right kinds of people for these. We don't put everything that you own in this type of trust, even when we do this as a Medicaid plan. No, you're going to keep some cash, or some life insurance or a small portfolio outside. Again, we have to get you down below $32,000. And then your IRA, 401, or your other retirement accounts, those always stay with you. They're not countable for Medicaid purposes. And there are some very negative tax consequences to try to put them in this type of trust. So for all those reasons, they typically will just stay exactly where they are. We just want to make sure that they're up to date. Your beneficiaries have been clearly laid out and that everything is just structured as appropriate. Biggest thing, again, Tommy touched on these. You choose a trustee, but you can change it at any time. You can name beneficiaries. You can change those at any time. And then the biggest, I think, thing that I think is surprising to people, Tommy, and I'm certainly asking for your input here, is when we tell people that it's an irrevocable trust, except you can actually revoke it.
Exactly. My clients always get confused about that, but what the key difference there is that you cannot unilaterally revoke it, and that's what's the biggest takeaway, is that it does require the consent of other individuals involved in the trust, and because of that, it makes it a little bit harder, and that's why it is okay for purposes of being approved for Medicaid purposes, because you alone do not have the power to revoke it yourself.
Yes. Yeah. And I think that's a really good, clear way to put it. I always like to joke and say to my clients, right, we're lawyers, how much can you actually put stock in like what we say? But there actually is a codified law in New York that allows you to do all this. So I'm going to be very clear with this. This is a New York principle. So if you leave New York, it's possible that where you do an irrevocable trust may not be able to revoke like we do in New York. So obviously this is advice for New York. So if you're watching from another jurisdiction, you'd have to speak with attorneys located where you are, see if that's still kind of a feature of the trust or of the state in which you reside.
Well noted.
So advantages to the trust, big one, probate avoidance, right? We keeps everybody out of court. That's another big benefit of doing a trust is we don't send anyone to court to deal with it once you've passed or once you've both passed. If it's a joint trust where we're doing it typically for spouses. We typically, the lawyers, I mean, when I say we win the most typically when people go to court. So one of the nice things is we keep you out of court, where everybody typically will win and we'll get a better result much quicker. It allows you to determine who gets your stuff and how they get their stuff. So this could be as simple as everyone just gets checks in equal amounts. If that's what you want, we sometimes leave further trusts in place where we're actually doing some further planning for your downstream beneficiaries, where we're looking to protect inheritances. We do a lot of that type of planning. It seems like more and more each year. Unfortunately, divorce is what it is. People are also getting older, and I think people are getting smarter as to wanting to protect not only their own stuff, but protect the things that they pass along to the next generation or even past that. So sometimes we layer in future trusts for that. You still have your ability to access your income and your assets, especially as long as you have good working people in your plan. You can fire your trustee at any time. That's usually my favorite part of the consultation is when I tell the children, if you don't do what mom or dad want, we get to fire the kids. And I'm happy to do that, right? As much as I hope that your relationship doesn't deteriorate where we have to have that kind of talk, I'm more than happy to fire the kids if they're not doing what you want. And again, we can revoke that irrevocable trust because there is a statute in New York that allows us to do that. And it also gives you the ability to qualify for Medicaid. So again, after 5 years for the nursing home, immediately for home care, again, with the caveat of we think there's that 2.5-year look back coming for home care. So the nice thing in our minds about doing an irrevocable trust now is that even though you could apply for community benefits right now if you needed them, right? If they do institute the 2.5-year look back, like we're anticipating is likely, right? We can't guarantee it, but we think it's likely. Then you're also getting the ball rolling towards getting through that 2.5-year period of look back if it ever comes into play. So it's something where you might be doing it now because you need it. You might be doing it more proactively, and everyone should do it for either of those reasons. It's just a matter of where you kind of sit. So let's do an example because that's a lot of words and it's a lot of concepts and it's a lot of information. And I do realize that we move quickly for these, but at the end, we only really have a half hour for content. So we have to keep it moving. So let's do an example. So this is Rachel. She's a widow. She's 84. She had a fall. She wound up in the hospital. And then she got discharged to rehab, and now things are a bit uncertain. So, and unfortunately, this is a very common scenario for us as planning attorneys where we get contacted by someone, typically of the family, right, kids or spouse, that something has happened to their loved one. They were in the hospital and now they're kind of trying to get better. And then who knows what happens after that. So we have to look at what she's bringing to the table from a physical standpoint. So unfortunately, we do have a dementia diagnosis where there is some disorientation. There might be some possibility of mini strokes in the past, but she's still verbal. She still can, she certainly can understand enough to do documents at this point. And then she does have a daughter who's close by who does help and check in on mom and does is starting to coordinate some care for mom. So again, unfortunately, this is not an uncommon scenario where we're starting to see some health issues for the person who needs the Medicaid or will need Medicaid in the future. But at least it's, again, just based on these facts, Rachel's good enough that she can still do some planning, right? This is another point of if you don't have any planning done, you want to make sure you do it while you're well, or at least well enough that you can actually do it, right? If I change one fact here and said she had dementia, does not have her capacity, did not do her,
Totally different
then
outcome.
we're talking about a much different scenario where we're talking about guardianship and all that fun stuff. And that's not where we're really where anyone wants to be. While we can certainly help with that scenario, it's not where you want to be. So we're not going to talk about that here. So we gave her some income and we gave her some assets to illustrate how this all kind of fits together. So she has some Social Security, she has some interest and dividends off her stock portfolio, she has an IRA that she's taking distributions from. So her total income is 2820, exactly $1,000 over her allowance. I just don't know how that happened. That seems very convenient. And then her assets are her home, an IRA, her checking and her savings accounts, and then a brokerage account that she's built up a little bit over time. So how this all works together is she can create and then fund a Medicaid Asset Protection Trust, just like Tommy and I just walked you through. And we'd mainly be moving in her home and her savings account. Again, her IRA is exempt. She's taking her required distribution, which is notated right over here with the $9.92 a month. And then the checking and savings, it's under 32,000. So we don't even have to move that. So her cash stays where it is. Her IRA is exempt. We move the home, we move the brokerage account, and now she's qualified. And then we have a pooled trust. That's a different type of trust. It's much different than the one that we're talking about today. So Tommy, do you want to talk very quickly how the pooled trust comes into play here?
Absolutely. So if we've qualified for everything except the fact that your income is over the stated allowance, there is a way around that by establishing what's called a pooled income trust that's run by a not-for-profit organization. And it's utilized to fund whatever the excess income is into that particular trust, which you then have the flexibility to use to bill pay. And so it's not a complete forfeiture of the income as it would be in a nursing home scenario, but you do have to channel it through this pooled trust, which you can use as another account to pay bills in order to be qualified for Medicaid.
Exactly right. It's kind of the lifeline, I think, of kind of how Medicaid home care can really work. Because without the pooled trust, you'd be stuck with surviving on $1,820 a month to pay all of your expenses. So your personal expenses, your property taxes, right, your electricity, your phone bills. So pooled trusts are kind of the necessary tool to kind of make this whole scenario work. And that's not to say the other issues the program is now having with aid availability, shortages, the CDPAP stuff, the new institution of PPL as the single fiscal intermediary. So there are other issues, but the whole plan falls apart from a financial perspective without a pooled trust in many cases. And we haven't done previous Medicaid Mondays on pooled trusts. I've done several now with Sarah Grimes, who's a good friend of ours from NYSARC. So if you have questions specifically about a pooled trust, certainly go back in the archive, check out the previous Medicaid Mondays. On the pooled trust, we do a whole half hour breaking down how they all work. So if we put all the pieces to this plan together, Rachel does her trust, she creates it, she moves the house, she moves the brokerage account. Now her assets now are $25,000 of countable stuff because all she has is her checking and savings account, which is comfortably under that 32,396 limit. Her income gets down to 1820, which is her allowance. And if we move very quickly, we could actually have her eligible as of July 1, because again, there's no look back period. So if we make all her stuff disappear into the trust this month, come the first of next month, we can now apply for Medicaid. Just to be clear on that, right? Medicaid looks at eligibility as of the first of the month. So Rachel was not eligible as of June 1st because she still had her brokerage account and her home. So we want to move stuff to the trust before the end of a month. So if we'd moved this month, July 1 would be our target. If we got held up with the brokerage count a little bit, August 1 would be our target if we funded everything in July. And then once we submit it, the Medicaid office, they obviously have some time where they have to process the application. So for a pooled trust scenario, it's 90 days from submission. Many counties, I think, used to be a little bit better about hitting their targets, but I will say, to their credit, we are starting to see applications get turned around a little faster than we were a few months ago. So if we're before 90 days, we always like to check in just to see if there's anything we can do to assist. But if it's before 90, there's limited things I think we can do comfortably with the county office besides just offer assistance and to check in. Or there is the immediate needs program, which obviously then will ratchet up of how fast things can be processed. It's much more like 12 days, I think, is the number. But again, there's different medical requirements for things for that. But just the take home point is it's unfortunately not overnight, right? It's not just we submit it and then instantly you get services. I wish that were the case, but reality is that that is not something that happens. And just to kind of give people just kind of, again, a rundown of the things that you would need to apply for Medicaid, besides doing all the financial eligibility, things like we've talked about today with the trust, is you have to have copies of your identifying documents. So things like your birth certificate, your IDs, your health insurance cards, your financial documents, so your current bank statements, right? We have to show what you actually own, either in your name, in your trust, whatever you have, we want to show them where it is. It's not a problem to show the trust or to show your IRA, right? It's fraud to not disclose financial information that does exist. You want to make sure that if you're working under a power of attorney, that you have a copy of it to show that you have the requisite authority to represent that person. So obviously that goes into the equation as well. And then one of the things, Tommy, that I think fouls up our clients more than anything with some of this stuff is that income information, right? You have to have current income information. So you want to speak quickly to that?
Yeah, so you got to make sure that as far as the retirement accounts goes, your social security, your pensions, you have to think of all sources of income, any dividends, anything that needs to be disclosed and proper statements to demonstrate that as well.
Yeah, and you want to have it as of this year, right? We can't use a 1099 for last year, right? As much as that would be great if
or an old social security award letter and just say this
exactly.
is
You
now.
have your cost of living adjustment, things like that. So, and then sometimes like I would say I think it's becoming more rare and more rare as time goes on that pension people or pension companies are sending out just earnings statements, if you will. So sometimes this is something you might not have a lot of documentation about. So it might be something where you have to actually reach out to the pension provider to specifically request this kind of stuff. With a power of attorney, it's something that certainly can be done and accessed. Just kind of throwing it out there of if we're seeing hangups with getting information, that's usually one of the ones that sometimes people aren't quite thinking about. And then obviously, if you have a nursing home, you need all this stuff, and then you need 60 months of records for all the accounts.
Right.
The savings, brokerage, trust, doesn't matter, 60 months, no questions asked. So essentially, next steps is plan now, right? What plan now for the future if you're not in need of assistance now, but you think you might in the future, you want to at least protect your assets if it is something that concerns you. If you have someone in your life who could use Medicaid home care, obviously planning now would be the best. Getting in under the gun with the potential look back coming, getting services started now. Again, because it takes, unfortunately, the time that it does, getting services faster typically is better. And then obviously seek guidance from people like us. We hope that you come to us, but if we're not in your area or for whatever reason we're not a good fit, please seek a qualified elder law attorney to help you with all this stuff. And obviously we're happy to meet with clients either remotely like this through Zoom, in person at either of our offices. And then just in case it's not clear, we also do the Medicaid applications. I do a lot of them. So if it's something where that you think we can assist with not just the trust work, but the application work as well, Tommy or I are happy to speak with you about doing that as well. So that's the end of the formal presentation. We hope that this has been informative so far. We're not going to end the program just yet, but next month for Medicaid Monday, so right in the middle of July, we're going to do nursing home Medicaid. So that talks more about the look back and kind of our crisis planning and some other options we have